Great. So once again, thank you everyone for joining this webinar. This webinar is about looking at access to information and its importance just as much as protecting personal information. So my name is Lisa Imaiwaha. I will be your host today. And my distinguished colleagues are John Giles, our managing attorney, Nathan Ross Adams, and also Mark Henk. And that is the Michalsons team and part of the Michalsons panel. And as a member of the information regulator, we have Alison Tilley here today to help us discuss certain aspects of PIA and access to information, and also to highlight the key importances of that information right. So as you know, access to information is really important, and everyone should have access to information so that they can use their voice and really hold both public bodies and private bodies accountable. So without that information, we won't be able to make informed decisions or very much really give effect to our rights. So one of the key outcomes that we want to get out of this session for you is for you to really understand the balance between the free flow of information and data protection, as well as also understanding and knowing how PIA impacts your organization, so that you can consider what those obligations are in terms of PIA and what you need to do from a practical perspective. So throughout this session today, we are definitely going to run some polls so that we can just gauge where you are in terms of your understanding of PIA, and also for you to understand your obligations from that perspective. And the chat availability is there, so you can ask us questions throughout the session, but please try and keep them focused on the topics we're going to discuss today. So Nathan will be coordinating that, and at the end we will have a Q&A session where we will look at some of the questions and discuss them and pose them to Alison. So I want to run the first poll. I'm just going to launch that right now. And it's really about us understanding the size of your organization. So I've just launched it. And how many employees do you have in your organization? You can just go ahead and do that.
Lisa, just to mention that 50 is obviously a key number, which is why this is interesting, because organizations with less than 50 employees are possibly exempt from having a PIA manual. So that's really interesting to get that feel of who's under 50.
That's so right, John. Thanks for that. So we'll just give it a few more seconds and then I will show you the results. Okay. So we just ended the poll. I'm going to share the results with you. And as we can see, this, as John mentioned, the key aspect here is looking at 50 or more. So about 29% of you have about 60 to 50 employees, which is less than the amount for a possible exemption in terms of the PIA. But more of you have over 250 employees, which means that a lot of you will have to have a PIA manual, or you already have one in place. So that's just key. A lot of people have more than 50 employees, almost more than half of you. So, okay, I'm going to stop that, and then we're going to launch another poll. So this poll is for us to understand what role you play in an organization, because it's really key, especially if you're the information officer or the data protection officer, you play an important role from a PIA perspective. So I've launched it, and you can just fill in the option telling us what role you play in your organization. Okay, we'll give it a few more seconds and then we'll show the results. Okay, I'm going to end the poll, and here are the results. So it's quite a decent-ish spread, but a lot of you are the information officer or you are in compliance. Some people are the head of the organization, so by default, you would be the information officer unless that role has, the responsibilities has been delegated to somebody else. Some of the company secretaries, some are in legal, IT, governing body, etc. So I'll stop sharing that. And I think I will just launch one last poll. So this is a poll dealing with the type of organization that you are, whether you're a public or private organization. Because as we know, the PI Act deals with not just accessing information of public bodies like the government, it also deals with accessing information of private bodies. So we'll give that a bit more, but I mean, from what I'm seeing, there's an overwhelming amount in one of the categories. Okay, I'm going to end this poll and share this result. So as I said, it's overwhelmingly, a lot of you are private bodies. So definitely, of course, as I mentioned, PI will still apply to you from that perspective. Some of you are public bodies, so there is an aspect of that that's important for you as well. And some of you are not really sure. Maybe you're a private body that does a public function, and maybe that's where the confusion is, but most of you are private bodies. Great.
Elisa, maybe just to add there as well, that in most countries in the world, access to information or freedom of information laws only really relates to the public sector. In South Africa, it's the public and the private sector. And the public sector is a key role player. And it's really interesting that 94% of the people on this call are from the private sector. I'm surprised there aren't a lot more people from the public sector, but I agree.
Thanks, John. That's a great point. So let's start with some questions, Allison, and really a key aspect of data protection and something that we tackle all the time is looking at the role of free-flowing information and protecting personal information. So those are key points. And I've just shared my screen with our Prezi dealing with access to information. And we're really looking at the balance of various information rights. As you can see here, we're dealing with, there's lots of different information rights, whether it's protecting information, whether it's privacy, access. But the key ones we're looking at really are privacy and access and the interplay between those two. And from our perspective, it really is like two sides of the same coin. Sometimes it's important to protect information, especially personal information, but other times we need to give access to it. And this is something that is highlighted in POPI. So you'll see here at section 2, it's important to note that when we're safeguarding personal information, we also have to look at balancing the right to privacy against the right to access to information. So Allison, I just want to ask you if you can touch a bit more on the aspect of balancing those information rights. Oh, Allison, you're muted.
Unmute, I know. If I may come at that question from a chronological issue, which is not the balancing of rights, but just historically, it's really useful, I find, to remember that PIA came first. So in terms of being quite specific in the Constitution with the right to access to information, and then the actual PIA legislation itself, which had to be passed by February of 2000. And what that meant is that I think the framing is really one of access to information. It's one of open records. Information is held both by the state and by private bodies for the benefit of the public. And they are also, where they are able to not disclose records for whatever reason, they also are doing that for the benefit of the public. These are rights that are at play. So the sort of opening of the discussion in 1998 to 2000 was really about openness. The question of data protection, as you'll know, isn't included in the Constitution specifically. There's a right to privacy, but there was very little in South African law that referred to data protection. I mean, there was a passing reference to the protection of personal information in a decision. But in terms of looking at data protection, it really did come second. And I think that helps us in a number of ways. It helps us frame the discussion. But it also, I think, helps on a practical level as well. Very often, I think the putting the two pieces of legislation side by side can sometimes there are anomalies or little glitches that don't quite match up, and that really is because of the sequential way that the legislation was passed. Transparency is a founding principle. It's part of the idea that we were making the transition from an unjust and undemocratic past to a culture of justification where the state, in all instances, would have to both have justification for what they were doing in terms of law, and in the same way that the state would then also be restricted from acting in certain ways. As John said, unusually the private sector is included in PIA. And it's really, if you look back at those founding ideas, it's because the idea that power can be constrained and managed through transparency. Sunlight is the best disinfectant. The more you can make open, the better your understanding can be of your circumstances and your society circumstances, and the better the decisions are that you make. So I think the framing has just in terms of the rights language has always been about access to information, and then privacy is a limitation of that right. In this context, data protection then becomes a limitation of the right. Difficult because then privacy is also a right in and of itself. So yeah, and that's where we come to the balancing of the rights and trying to figure out at which point which one takes precedence. And I mean, that's really the point of PIA, is give effect to the right to access to information. So it's the intention that you can, you go to PIA, and in the principle of subsidiarity would apply, that you can't then go around PIA to the right itself. You work through PIA. And we can talk a little bit more about how that hasn't worked. But yeah, just, in summary, the right to access to information principle. And I think it's always useful to remember that.
Great, thank you so much, Allison. And I agree, because you framed it with PIA and access to information came first. A lot of the times, especially from a private body perspective, we always like to think data protection first and leave PIA as almost as the unloved redheaded stepchild, to put it bluntly. But it's important that we really try and refocus and recenter and understand that giving effect to those rights, and especially a right to access to information, is really important. I don't know if anyone else in the panel would just like to add something from that perspective.
Yes, I think from my perspective, it's really interesting that POPIA actually says in the preamble that there needs to be a free flow of information, and data protection law is not trying to stop the flow of information. And so they're two sides of the same coin. Access to information is all about trying to increase the flow of information. Data protection is about protecting just personal data. But the two are two sides of the same coin, and you really can't talk about one without the other, which is why the information regulator regulates both aspects.
Great, thank you very much, John. Mark, do you have anything to add?
I think sorry that I've come in late, and sorry to everybody else if there's been any interruption as a result of it. I think that it should also be remembered that initially it was intended that these two rights be dealt with together. There was something called the Open Democracy Bill, and then it was decided that PIA would be dealt with separately. I think at that time it was felt that the access to information was extremely important, given, as Alison has said, our history. And one of the things is that with any of these acts, it is not really what the act says, but how it is actually administered that becomes extremely important. And from my perspective, I was one of the people that advocated quite strongly that the regulator have a remit over both access to information and data protection. And I believe that we really do need a strong regulator in South Africa to deal with these issues. We've seen in the past that the South African Human Rights Commission has not really fulfilled the function properly, and one can argue that it was never really their role. But the point is that, for instance, the revelations around the Gupta tapes and what has happened with state capture, that didn't come about as a result of access to information. Quite on the contrary, there was a lot of blocking of access to information that should have been made available. That came about as a result of, in effect, an unlawful leak of the emails, the Gupta emails. So the importance of transparency is absolutely critical to a democracy. And I certainly hope that in the future we're going to see much stronger regulation of how we get access, and people not paying lip service to it and just using spurious grounds for refusal to refuse to provide information where access should actually be granted. Thanks, Lisa.
Perfect. I really agree, Mark. And Nathan, do you have anything else to add?
Yes, I'd just like to say, well, emphasizing on what Mark and Alison has said there was a very important political context for PIA being first and access to information being prioritized. But what's important to remember is that it's part of a general scheme of information laws that the state intended to apply across South Africa. And so, for example, the Protection of State Information Bill will also become relevant later, and the Cybercrimes Bill will also have a big role to play in how information is managed in South Africa.
Thanks very much, Nathan. That's a great point, because it's a holistic framework where we're dealing with different rights and different interests, and we cannot, and it's something I guess we're all emphasizing, is that we cannot see them as separate. They're linked, and it's important to really think about them when you're dealing with both any kind of information right. And something that we've mentioned and we've reiterated a lot just now is the importance of transparency. So from our perspective, we really believe that access to information will lead to transparency, because if you have access to the information about certain things that deal with you and that's available, you're able to make better decisions and to hold, for example, government, public bodies, and in our case in South Africa, private bodies accountable and make sure they do the right thing. So the principle is really about making sure that we have that kind of availability in terms of information. So Alison, I really would like to ask you you've mentioned it a bit, but I think let's delve into it a bit more about the importance of transparency, and also looking at it from maybe a POPI perspective, because that's also a principle. One part of the principles of data protection is transparency to a data subject.
Well, I think the theory and of course the practice is a different matter, but the theory is that open I mean, open records, open courts are all foundational in a democracy. It's certainly gone with the My Vote Counts decision in an interesting direction, where a court has said, look, you know, PIA is not actually giving effect to the right to access to information sufficiently in relation to this category of records. And at the transparency demands, you know, specific treatment in relation to records around party funding. I mean, I would think that that same logic and that same way of thinking can be used in relation to a number of different records, which one could look at. And I think particularly, and I mean, it's always surprised me, but there it is. In other jurisdictions, many businesses use access to information extensively to learn what the state is doing and to understand what the decision-making processes are. And it may be that people are simply, you know, don't know about that, or feel that such a, you know, interestingly, people often feel that a request for information from a public body is quite an aggressive thing to do, which I've never understood. But especially if you have a relationship with a public body that you know, they're perhaps a regulator that you fall under, that somehow that means that a request for records is would be a confrontational thing to do. I would regard it as part of business as usual. Transparency is not, you know, it's not just a human right. It's a way of doing business that can really advantage people who are not the state, because the state is massive and opaque, and, you know, one hand does not know what the other hand is doing. And it really can be the role of the private sector to bring, you know, sunlight to those processes and those decisions. And it's exercising a right, just like you would exercise the right to carry on a trade, or, you know, be part of a profession. So I think the usefulness of transparency is something that I've not really seen business grasping as a sort of principle for particularly doing business with the state, but any entity that undertakes sort of public functions, as you correctly point out.
Great, thanks, Alison. That is a good point, because I don't know if it's whether it's a situation where people don't know they have this right, so they don't want to enforce it, or as you say, they're just afraid, because maybe to them they think, I'm going up against government, how can I do that? But it is within your rights, you know, you have the right to know what's going on. How else can you make decisions? How else? It's things that affect you, so it's important to try and enforce that. You make a great point. Thank you. Anyone else from the panel who would just like to provide their input on that, the aspect of and the principle of transparency?
Just Lisa, to deal with the sort of the overlap that we see in the PIA, Section 18 deals specifically with notification. And the purpose is to provide that transparency. You know, if you don't know who has your information and how they might be dealing with it, you can't really enforce your rights, your right to object, your right to have information corrected. So there is that strong overlap relating to transparency in that regard. Thanks.
And Lisa,
that's a great point. Thanks, John.
If I can maybe just tell a quick story that for me really illustrates what PIA is all about, because a lot of people have asked me over the years, you know, what really is PIA about? So we had a situation in the office where we bought a lot of biscuits, some delicious biscuits like Romany creams and cream crackers and boudoirs, and we had them in a cupboard in the kitchen. And they were getting eaten really, really fast. And there was a lot of speculation around the office as to who was eating all the biscuits. There were a lot of fingers pointed at me, and I felt unfairly. There were quite a few fingers pointed at Sicelo. So what we decided to do is we took all the biscuits out of the cupboard and we put them in a big cookie jar in the middle of our open plan office so that everybody could see who was going and taking a biscuit. And so what happened is the biscuits got eaten a lot slower. Coincidentally, a few people pointed out to me that I'd lost quite a lot of weight, which was a really good outcome, and I think was maybe quite telling as to who the culprit was, as to who was eating all the biscuits. So it really is just a great example of exactly what happens with transparency. When something's out in the open and everyone can see, it self-regulates. It forces people to become accountable, and the benefits are enormous.
Great. Thanks for that story, John. And yeah, accountability is very key. Nathan, anything from you?
Yeah, I think as a society generally, we're not realizing the value, at least that's attached to transparency, and how important it is going to become in the coming years, and currently is. I mean, as you know, I'm very passionate about emerging technologies, and there's the idea that there's transparency, which is openness when it comes to the types of information, but there's also explainability, where people actually know what's happening to the information in detail. And within the context of technologies like artificial intelligence, there's the risk that if transparency isn't prioritized, people won't actually know what's happening with the information. So using the example of black box AI, which is AI which doesn't where their reasoning models aren't clear and people don't understand what they're doing, transparency becomes a bigger issue, because how do you get access to information where you don't know what's actually being done to that information? So I think it's going to play a crucial role in South Africa, especially in the fourth industrial revolution and what's happening with emerging technologies.
Great. That's a very good point, Nathan, because it is going to affect every aspect, whether it's we're using AI, we're just trying to find information from government. It's important that we really try and give effect to our right to access to information. And just to jump off of something that Mark has mentioned, so he was discussing notifications in terms of Section 18 in the POPI Act. So these are notifications to data subjects. And it's really about a data subject understanding what kind of information that you are processing about them, what information you hold, etc. And with our PIA manuals, we kind of have a similar thing where we discuss the types of information and types of records that we hold and the different categories of information. And something we've just noticed is that there's not really clear guidance as to this notification, either to data subjects and how to really implement this. Is this something that you can comment on, Alison, from that perspective, for us to understand really how to implement that level of notification?
Yeah, I mean, I think it has come up, and one of the difficulties is where you as a responsible party have many different data sets, a lot of details about people, you know, and really what is your responsibility in those circumstances. And I think I at this point, when it comes to data that you already have, I feel that a relatively robust attitude is needed. You know, if you end up in a situation where it's just not going to be reasonably practical to notify, I think the Act and the regulator shouldn't be in the business of creating, you know, obstacles in the way of people doing their work. I think going forward, there's a couple of things. I mean, one of them is simply being able to design your information systems so that you know when you actually have personal information in that system. I feel like there's a real difficulty for organizations in having a sort of an information audit trail on where information has come from. and the idea of when you are processing that information, then being able to notify people. I think it's quite tricky, and I'm not sure how many people have really thought about how they're going to do that. And I think the regulator would be entitled to ask some questions about, you know, have you thought about that? What are your processes in place to do that? Because it's pretty foundational as a principle that you need to know when somebody's processing your information. I mean, that's one of the sort of key ideas. And if your systems are not set up to allow you to do that, I think then then you're going to run into some trouble.
Definitely. And I think one thing that was brought up is just looking at it from a legacy information perspective. Of course, when it comes to new information, it's easy maybe to have it in your privacy policy, say, this is the information we process. But what about legacy information we've been processing for a while, and we're trying to align to the POPI Act and trying to notify the data subjects? I think that's the trickiest part for a lot of organizations.
Yeah, no, exactly. And I think that, you know, the difficulty for the regulator and for everybody else is that there is no jurisprudence or guidance or practice on these things. So, you know, it's always that trick of saying, well, what exactly will this look like? And the answer is, well, I guess we're going to find out. But I think the regulator must be guided by the intention of the legislation. And I mean, obviously it's a creature of statute. We can't go beyond the limits of the legislation exactly as written. We can't just sort of interpret it in new and different ways. We're not a court. But it's certainly something that I think, you know, that's why a section like that is in the legislation, precisely because of, you know, the question of where it's simply not feasible.
Great, thanks for that, Alison. Mark, do you have anything to add from that perspective?
One of the things, and Alison and I have discussed this previously, you know, one of the things about PIA is that the intent really is not to create an additional administrative burden. Quite on the contrary, having a manual should actually advise people what information you have and what they can get freely from you without going through the PIA process. Or, you know, where it might be appropriate to actually deal with it in terms of your rights that are established in PIA. So I think that one of the things that has happened, and I really would advise a lot of companies to re-look at their PIA manuals. In many instances, they've been drafted really on the basis of, let's do this because the auditors require it, and in case somebody asks, we can say we've got a manual. And they haven't been looked at, frankly, for the last 10 years in many, many instances. Whereas now with data protection and this coming into play, it does cast a slightly different light on this. And Alison mentioned just a moment ago that very few systems have been developed with being able to identify what personal information you're processing. Because we haven't had data protection law in South Africa, privacy by design has not been an issue in South Africa, whereas it has been in many other jurisdictions. And that, again, will inform, I mean, the PIA manual is there to assist in this transparency. So I do think that it is necessary that we look at notification and the PIA manual together and see how we actually deal with these issues, and don't try and put them in different silos. And for goodness sake, I think just as we determined eventually in Parliament that the regulators should have remit over both the PIA and PIA, when you have an organization, don't have one information officer that is devoted to PIA and another devoted to data protection. You're going to just get turquoise. So get somebody who's going to look at the balance between the two and the significant synergy there is between dealing with the two of them together. Thanks, Lisa.
That's a great point, Mark. And just to even jump off of that point, the supervisory and supervision aspect, whether it's as the information regulator or as the information officer for an organization. So as we know, and which is quite key when we're looking at the information regulator, they are not the POPI regulator. They are the information regulator. And you'll see here in this picture that it even states that it's about ensuring the protection of your personal information and the effective access to information. So both of those two rights are highlighted from the beginning. And it's related to that is also the role of the information officer in terms of what they have to do and their responsibilities. So information officers, of course, have a certain responsibility, apologies, in terms of PIA. And it's clear that a lot of the times people don't acknowledge that that is one of their roles. So Alison, I think if you can just touch a bit more on the role of the information officer, as well as the role of the information regulator, especially from a PIA perspective. Thank you.
So Mark makes a good point in relation to the role of the regulator, which is definitely to deal both with PIA and with POPI. And one of the things that we really lobbied quite hard around was the powers of the information regulator. The Human Rights Commission really had powers which were sort of, advisory recommendation only. And we were seeing that that wasn't really sufficient, which is why the regulator has order powers around the release of records. I think that was a very important part of the thinking around it. The idea of the information officer has its genesis in PIA as well. The idea was, what we were seeing at the time was a lot of, in many different structures in government, and particularly in where there's intersectoral structures, the most junior official that you could get away with was the one that came to meetings. And that was something that we were very concerned about, which is why the idea of the information officer is that it's by it's de jure, it's something that's it's decided by law, and it's senior. It's as senior as you can get, and of course trying to define what exactly that means is tricky. And I think there are certainly, we're finding people who are saying, well, is that me or is that somebody else? So the guidance note on that is where we are right now. But I think there are instances where we're going to have to try and be more helpful on what exactly that is. But the intention was that it's the most senior person who has charge of information, and they would finally be responsible for making sure that the legislation is implemented. So particularly in a government structure, that it is a very senior person who is able to basically give orders that would then apply through more or less throughout their, throughout the organization. So that's where it started. We then had deputy information officers in terms of PIA, and they would then take on the role of, managing requests and keeping a register of requests and making sure answers got given. And that framework, that structure was then used in POPI in order to do more or less the same thing. And I think that the role of the information officer is something that for some reason people are not, I don't feel they're embracing it with the delight that perhaps we thought. People are concerned about being the information officer. They feel it brings risks and creates a role that they don't understand and that they're not necessarily comfortable with. It would be my suggestion that the role should be seen as the steward of the information in the organization. There is, you know, there are information flows in organizations all the time. The idea is that there's somebody at the helm who should be taking that responsibility seriously. Is really the guiding principle, and I think that you know, I think it should be approached in that way rather than what we're seeing now, which does seem to be people trying to find a way to outsource it, or, you know, make some, you know, hapless low-level employee take that on. That's really not the idea. If you lead an organization, you have to lead on these issues as well, and that's, you know, that's just how that is. There are rights that people have and responsibilities, and that's really, if you want to lead an organization in the 21st century, something you're gonna have to embrace.
Definitely, that is a very good point, especially because when we think by default in terms of PIA, it's the head of the organization, it's the head of the body. And a lot of the times it might make sense, as you say, to maybe delegate that role simply because someone else might be the proper information steward and know where the information flows are. But yet again, like you said, it cannot be just a random Joe who just started yesterday. They cannot be the information officer. And I think the guidelines make that clear, that it has to be someone senior and in management who has that level of understanding and can say, this is what we're going to do, for example, with a request. This is what we're going to do here, etc. So I think that a lot of the times, maybe it's because of the POPI expectations or the data protection expectations that people shy away from that. But once again, we can't separate data protection and privacy from access to information because that role is so intrinsically linked. Anyone else in the panel with something to add?
Yeah, just when it comes to the way companies are changing again. So I think we can all acknowledge that everyone's going to become a data company. Everyone has a component or IT component in their company, which means that they're going to be processing some sort of data. And then the second point was about the impression that everyone has of the information regulator. Yes, it is going to be playing a very strong supervisory role. And I don't know if Alison maybe wants to speak more to this, but I do believe that there's a strong mediation role that they also have, where they would mediate the interests of different stakeholders. So whether it's companies in the private sector, the public sector, as well as the different rights that are competing at the moment.
Yeah, should I just chip in on that? I think that certainly is the intention of the legislation, and I think there's quite extensive powers around mediation. The regulator will have to, just in terms of you know, the processes within the organization, because there is an enforcement committee. We need to have a situation where the enforcement committee and members sitting on the enforcement committee are not conflicted by the time a dispute reaches them. And that's going to be an interesting question, because obviously if you've plunged in to a mediation, it would then be very difficult, I think, for the parties to accept you as a neutral decision maker on the enforcement committee. The enforcement committee is led by a judge. It is important that it be seen as you know, not unfair, not biased. You don't want applications for recusal of members of the enforcement committee. So quite how those Chinese walls get built, I think will emerge. But there is definitely an important role for the regulator to, you know, to get in. One of the things that I think we've learned about access to information is very often it's not actually the bureaucrat who wants to hide the information. It's that they feel they don't have permission to release it. And the safest thing for any bureaucrat is to do nothing. And I think that's one of the things that we have to get around as a sort of a permission letter where you're saying, look, this information should be in the public domain. You have to release it. So I think there's roles for the regulator that are just about establishing a practice, which people then can get comfortable with over time.
Definitely. That's a great point, Alison, because we haven't experienced a regulator, so we don't know what's going to happen. I think once we get into that groove, I think people will be more aware of what their role is in relation to supervising enforcement and things like that. But we need to get to that point. So as 1 July gets closer, we'll see what happens. John, I see your hand is raised.
Yes, just from an agenda perspective, I've been noting the questions coming through, and we've had about 70 questions. I don't think I've ever seen so many questions in the Q&A box. What Nathan and I are doing, and Mark, we're looking at those questions, and we're going to try and answer as many of them at the end as possible. We've got a few more topics to discuss, and we've allocated about an hour and a half. So please hang around. We're not ignoring your questions. We will answer as many as we can at the end. But sure, there are a lot of questions.
Great, thanks very much, John. Another important aspect linked to what we've actually discussed a bit is looking at the differences or the distinction between a data subject access request, because we've been speaking about requests quite a bit, as well as a request in terms of PIA. So Alison, I think, can you just explain to the attendees what the difference is and the fact that there is a distinction between the two?
Well, I can certainly address that in principle. I mean, previously in PIA, it did both. So it tried to create a situation where you would be able to access your information and correct it, and that was the limit in terms of PIA. So that whole section was then removed, and POPI then took its place. The requests in terms of PIA, if it's in relation to personal information from the public or private body, and how that information is being processed, you would want to use a POPI approach. Whereas if it's for records, and I think this is often something it's unfortunate in some ways that it's called the Promotion of Access to Information Act, because it probably should have been called the Access to Records Act. Records widely understood, including a sort of, databases, but it's really access to a static set of records, whereas POPI has much more to do with what is being done with those records or done with that information. So I don't know if that helps in a sort of a conceptual distinction between the two, but that's always the way I've thought about it.
Definitely, and that's true. Just based on the wording of PIA, for example, it always talks about records. Yes, within that definition, it does include information and different mediums, but it is focused on records. And I guess that also ties into the fact, and something that you've mentioned, access to information request right that we have is quite broad. It's any record that allows me to exercise or enforce a right, and any right, as long as I can establish that that right exists. So from that perspective, I think it's really very much broader than the data subject access request, which is very much about what personal information does a responsible party hold on me, and I would like access to that. So it really is two things that are quite similar, but should be treated differently based on the scope. Mark, do you have anything to add from that perspective?
I think that one of the things is just remember that in both the PIA and in PIA, if you are requesting your own personal information, and that's really, there are a lot of redundant words in that, but in those instances, it cannot be denied. It has to be given to you. Whereas if you are requesting information which relates to other records, and particularly where it relates to other parties, then it is incumbent on the party to whom the request is made to look at whether there are grounds of refusal that apply. You can't just give those records away. First of all, the important thing is that you have to establish the right that you're wishing to protect or defend. And secondly, you have to then ask for information that obviously applies to that right, but there could be a ground for refusal. For instance, let's assume that you ask for a record which is a database which has my information in it, but it also has the information of lots of third parties. That cannot be given. You can ask for my information and possibly that information can be provided. But if there's third-party information, and particularly if that is intended to be confidential, the request is not entitled to that information. And in fact, the grounds for refusal is imperative. It says you must not give that information. So there are those distinctions that are important. And I think, coming back to Nathan Ross's point, we are increasingly becoming an information society. The importance of PIA and PAPIA are not that they are administrative bits of legislation. They are really defining, and this is around the world, how people actually deal with their information. So they are part of a greater global jurisprudence. And the point is that it's not to satisfy Alison as the regulator that you're doing the right thing. The real thrust here is to ensure that you do the right thing, because if you don't, in time you will be disqualified from doing business. Certainly data subjects might disqualify you, but other people that are processing information, if you don't process your information properly and put in the appropriate governance and the appropriate protections, then you'll be found out, and ultimately people will not really want to do business with you. So it is part of a revolution, and it is a revolution. Let's just face it, we are just processing so much more information than we've ever processed before. And these are two of the elements that have a dynamic tension between them that govern how we deal with information. And that is important in any organization. It is part of our future business. That's what we've got to look at it as. Thank you very much, Lisa.
That's a great point, Mark. And just before I ask for input from the other panelists, I'm going to run a quick poll on requests, just to really see how many requests our attendees have received for access to information, if they've received any at all, and just to gauge how you're dealing with requests, because I think that this is quite important, just based on from 1 July or even before that. Okay, I'll give you a few more seconds. I don't know, John, if you want to add something related to requests.
Yeah, I think it's interesting to consider whether the situation is going to change from 1 July. The regulator is planning, as I'm aware, is to do awareness programs and to raise the profile of access to information. So you might get very few now, but that might change into the future. And that's part of what we're asking here, I think.
That's a good point, John. I'll just share the results.
Another point on that really is that, remember that once people become aware that if a request is not acceded to, that instead of having to go to court and the expense and the difficulty that we have in actually going to court, that you can take your complaint to the regulator. I suggest that there might be a lot more people that are inclined to actually make the request in the first place, because in a lot of instances, particularly with government departments, etc., in the past, people have said, well, what's the point? We'll make the request, it'll be refused, and then I've got to go to court. Well, I'm not prepared to it's not worth the candle. Whereas if you can go to the regulator and it is a far more streamlined process, it may well be that requests become far more plentiful than what they are at the moment.
That is a great point, Mark, because it's accessibility as opposed to going directly to the court. I can approach the regulator. And as you'll see from the results, a lot of you, quite surprisingly, haven't dealt with quite a few requests. Most of you haven't. Some expect to deal with requests post 1 July. And there's a scattering of people who've dealt with requests. Some have had 1 to 5, some had between 6 to 15, and very few of you have had over 100, but I guess that really relates to the type of organization that you might be. Okay. Another key aspect to this is really, I know we've mentioned it before, is having a PIA manual and what that's about. So I want to just launch a quick poll related to PIA manuals, just to see if some organizations have them or not, if you're currently exempt, and really where you are in terms of your PIA manual.
Lisa, just a point linked to this, and maybe one of the panelists can take this question, but it's, can an organization, or whether public or private, mandate whether a data subject needs to follow a specific route? So for example, if they need to do a DSA or data subject access request, or a PIA request for access for information. Not all at once, everyone.
I'm not, the answer is I'm not sure. I mean, if you want, okay, well, first principles. If you are an organization that has information, the intention of the PIA manual is that it lists the information that you have, and that it indicates in that manual what is automatically available and what is not. And what people have been doing is doing a standard list of the information that you might expect to find in an organization in very broad terms, and then banging that up on their website and going, done. Now, the intention was that organizations would actually think a little bit about it, what information they hold and what information they cannot just release because of whatever, you know, it depends on your business. It might be proprietary information, might be security information, whatever it is, that you would then say to anybody approaching you, either this is automatically available information or it isn't for some reason. And we would then ask you to do a PIA application, and we will then process it in terms of PIA. Now, that may have been the intention, but I'm not sure that the legislation really gave effect to that. And what ended up happening was that as far as government was concerned, everything became a PIA request. So if you wanted to refuse information, which you generally did, you would say, you know, you're going to have to put in a PIA request. That may change now a little, because the regulator would then be in a position to say, actually, that's information that should be automatically available. We'll be encouraging people to proactively make information available. A lot of information can go online, you know, at little or no cost to organizations. So I think we're really going to be focusing on the proactive release of information and reserving a PIA process or a process in terms of POPI for only in those situations where there is some exemption or reason not to make that information public.
That is an excellent point. No, I think you've answered it. It really deals with that aspect, and it's something that we wanted to discuss. So just linked to that, I want to share the quick results for the PIA manual. A lot of you have said that you do have a PIA manual and it's up to date. That's great. I hope you've also considered the aspects of POPI that you need to put in your PIA manual. A lot of you have one, but you need to update it. There's some drafts and a few people are exempt. And I just want to touch on something that Allison has mentioned here in terms of disclosures and in terms of voluntarily disclosing what is automatically accessible. And it's actually something that Mark has mentioned. People treat having a PIA manual as just another checkbox, tick box exercise. I have one. This is it. I'm not really going to engage in the type of records I hold. I also don't want to give enough information because I don't want people to ask for more information. I've experienced clients asking us, what should we put in our PIA manual? If I say this, they're definitely going to ask about that. And that's not necessarily the case. And Alison, I don't know if you want to just touch on that a bit more. I know you've discussed it a little bit, but I think it's really important to emphasize that it's not really like a fact-finding mission. It's if they're trying to enforce a right or protect a right that they'll ask for access to certain records.
So I think you always have to distinguish between public bodies and private bodies, because for public bodies, and this often comes as a surprise to them, you don't have to have a reason. You can just ask. Private bodies have a different framework, and you do have to show a right in relation to the record. If you want to make it really easy for yourself, I would say just work out what records you can make public, and if they're electronic, just make them available. Just don't even argue about it. It's this idea that we have, and we have a history of secrecy as a country. Whether it was the ANC in exile or the former regime, or both together, which was just a perfect storm of belief in secrecy as a way of operating. This is really trying to move us away from that. And in other countries, they really are embracing it, particularly in government, local government committee meetings. Is there a minute? Great, put the minute online. When is the next meeting? Put it online. It's the idea that you are changing, whether you want to or not, the way you do business. You can change towards transparency, and embrace it, and I think, as Marcus correctly said, meet international standards and meet best practice, or you go the other way. And I don't think that's the way to go for practical reasons as well as principle reasons.
Definitely, that makes sense. And I guess this is where the draft regulations might help. Once those are in effect, people understand, okay, there are certain things I have to make available, and then they'll be giving that guidance from that perspective. Anything to add there? See, Mark, you unmuted yourself.
Alison, one of the things that I think is quite important from a practical perspective, and I'm sorry, it might have been dealt with before I came in, but the 1st of July deadline, what is the remit of the South African Human Rights Commission, and what is the status quo with that, and what will actually be dealt with by the regulator? I think that's quite important for many people in the conversation.
Having had a look at the legislation, as far as we understand it, the regulator cannot take over complaints that have been forwarded to the Human Rights Commission. We have to deal with those applications de novo. We have to get them and then process them. What I would say, and I'm not sure that this has been made public yet, but just that there has always been this set of exemptions around PIA manuals, and this is a DOJ set of regulations, but we've asked that that exemption continue for 6 months to give people an opportunity to get their PIA manuals in place, because I'm not sure that people have always understood. They understand that POPI's coming into operation, but it's like, guys, so, just in terms of the regulator's mandate, to give people a chance to get those sorted out, and that's going to be gazetted. So again, the intention is not to catch people out, but just like, this is a useful, helpful, good thing that you really need to do, and the better you do it, the more you're thinking about what information you're making available. I think, the higher level of trust that communities and other businesses can have. So yeah, just to say that that's in the works.
I just want to clarify my own understanding, Alison, if you don't mind, and that is, if you have had a complaint which you referred to the South African Human Rights Commission previously, and that complaint has not been dealt with, can you then withdraw that complaint? Probably would be the best way to deal with it, and then put it to the regulator after the 1st of July. Is that
You don't
intent?
you don't have to withdraw it. It's just not relevant for our purposes. We need a new application.
Okay, so regardless of when the activity that was complained of, and probably in a lot of instances the refusal to provide information, that could be referred directly to the regulator from the 1st of July.
We would then be in a position, but so, for example, if you've made a request for records, and you've sent that to the Human Rights Commission and they haven't dealt with it for whatever reason, and now you're lodging an appeal, or you're part of that process, it's simply that we are not going to be able to simply take everything that's in front of the Commission and just deal with that ourselves as though we are a continuation of the Human Rights Commission, because we're not. We're a different entity. So you would then be responsible for making sure that it moves to the regulator. You can't assume the regulator is just going to take over what the Commission has.
Yeah. Okay.
Thank you.
You look worried.
Sorry, if I could just go back to the manuals and the exemption. It's a question we get asked by many people, and I can see there are quite a few questions about it now. Since PIE was enacted all the way back to about 2002, there's been an exemption in place for certain smaller organizations, and that was granted for 5-year periods, and then it was extended for 6 months to 1 July this year. It's great to hear that that exemption is going to be extended for another 6 months. I think that's a really good result and an important thing to do. My question really is, shouldn't that exemption be in place forever? Because there's certain smaller organizations that, for example, a coffee shop, who it doesn't make sense for them to have a manual. So would that exemption be extended for longer than the end of this year and be a permanent exemption?
I think the decision at this stage is a 6-month extension. I think you make a good point around smaller businesses. When that is gazetted, I think it's the sort of thing that would be useful to write to the regulator about, and just to keep it on the, not on the back burner, on the front burner, and ask the regulator to apply its mind to that, because we will have to go back and deal with any extensions in the next 6 months.
Okay, perfect. And one other related question is that in the session that the regulator did a few weeks ago about their readiness and strategy going forward, we think that you mentioned that the regulator might be working on a template PIE manual for public and private bodies, but we were not sure. Is that something that's in the pipeline?
Not to my knowledge, but I would have to go back to my colleagues and check. Okay. There's certainly guidance. There's how to deal with PIE, so a PIE guide, but I'm not sure that would count as a template. Okay. I would need to check in with my colleagues on that. My sense is that there's a guide, but I'm not sure that guide would amount to a template.
Yes, and I think possibly that's the confusion on our side, is we may have thought that you were mentioning you're developing a PIE guide, but we thought as a template. I agree with you. I think it probably is a guide, not a template.
Okay, yeah, that would make sense to me.
Yeah, and that is one of the requirements in terms of, it's the role that the South African Human Rights Commission had. They have the PI guide, the latest version, and that role will obviously also be taken up by the information regulator. And just to touch on the exemption issue, something that we've experienced is that it's not just about who's exempt. Sometimes the sectors or the industries that are described, a lot of people struggle to figure out where they fit in, because the definitions in some, well, in some sectors, there's no real guidance, and you can fall under anything essentially. So will there be any steps to change that or improve that so that people can really understand exactly where they fit in, if they fit in?
Yeah, there's no process in place around that, but again, if that's something that would be helpful, yeah, raise it formally with the regulator.
Great, thanks, Alison. I'm just checking to see where we are with time in terms of our topics. And I do think that we have some time to just run another quick poll, just to see if there's any additional issues anyone is interested in, and would want Alison to touch. We've touched on quite a few things. We've looked at certain issues related to the PI manuals. We've touched on the role of the information officer and the regulator. Of course, access requests. I just want to see if there's anything else, and then we would open the floor for questions, because there is some time for some Q&A.
Well, Lisa, while we're dealing with this, with the poll, one of the general questions that people have been asking over the past few weeks is whether there's something that they need that would be a POPIA manual, whether something like that would be in the works in the future, or whether it will just be converted into a general organizational information manual that they would need to publish on their sites. Is that something anyone could answer? Oh, Jonathan, Alison.
Well, Alison, go first. After you.
I've been working on a PIA manual, so that's my remit. The manual doesn't deal with POPIA, so not to my knowledge.
Yeah, listen, I agree with you. There's somebody came up with the concept of there being a POPIA manual in addition to a PIA manual, and you needed both of these manuals. And they've been, I think, quoting and trying to sell a POPIA manual. And for us, there is no such thing. It doesn't exist. The law doesn't require you to have a POPIA manual. The law does require you to have certain things in your PIA manual that relates to data protection. And what we generally suggest to people is that you should really have a PIA manual and a privacy policy. Your PIA manual refers to your privacy policy, and the privacy policy performs that role of being transparent, disclosing your purposes. Why do you collect information? What are you going to do with it? Who are you going to share it with? That's really what your privacy policy deals with. So be very cautious of anyone trying to sell you a POPIA manual, because in our view, it's not something that exists. And I think most of you are larger organizations on this call, but for the smaller ones, also be very careful of people trying to sell you a PIA manual, because you might well be exempt. So you don't want to go and spend money on something that you don't need to do anyway. And this has caught many people in the past. And I just urge you to be careful. If you may be exempt, check whether you're exempt, because the last thing you want to do is spend money creating a manual that you're exempt from having to do anyway.
Great.
It's just a sort of story from when the PIA manual was first introduced. There were no exemptions, and I was working at an organization that was giving advice on PIA manuals, and I think there was a week where we did nothing but answer the phone, everybody in the organization, trying to, just explain to people what a PIA manual was. And my favorite caller was from a butcher's in Plettenberg Bay, saying, "Why do we need this thing? We're a butcher." And that was part of what we then said to DOJ at that point, to say, this is not working. This is not working. And so then the exemptions framework came in. So I think it's an important framework, and it's important to make sure that it works in the right way, so that yeah, you know, the butcher in Plettenberg Bay is not the intended target of this.
Yeah, that is a fair point. I guess it really is about, like you say, there are some intended quote unquote targets for this kind of access rights and to get access to their information. And really, I don't know if we really want to know about the sales records of a butcher or not. I don't think that that's relevant for us to exercise our rights. So I'm sharing the results of the aspects that the attendees are interested in. I see a lot of people are interested in the new PIA regulations, which we did touch on. I don't know if there's anything else you want to add from that perspective, Allison. People also interested in PIA manuals and notification, which we under POPIA, which we did mention. A lot of questions about PIA manuals and the issues regarding them. So just linked to that, Allison, from a 1 July perspective, what do I need or what do organizations need to have in place by 1 July from an access to information perspective?
You really, if the right size of organization, you need a PIA manual in place. You need to have decided who your information officer is, and as I say, that's an operation of law. It's not. I do understand that frustrates people in many ways, but that is how the legislation was designed. The question of registration of information officers is one that is a vexed one. And the reason I say that is because it was intended that there would be a portal where you would be able to register. And there are some things that registered information officers do that unregistered ones don't. To me, it's not, I don't think a great deal turns on the distinction. The difficulty is quite simply that the portal is not working. And I think that's frustrating for many people. It's working for some applications, but if you have your ID number linked to more than one company, the system will reject you. You can enter your ID number and it'll tell you that you've already registered using that ID number, although you have not. So there are various problems that we are very much aware of. They always say that the technicians are working on it. The technicians are really working on it. To what extent that portal will be fully operational, technicians are working on it. That's as much as I can tell you at this point. But I know that it is a frustration.
Definitely, I can understand from that perspective. So in terms of questions, unless the panelists have anything else to add, maybe we can start looking at some questions. Okay,
awesome.
great. Nathan, you can just pick out certain questions that you think are important to direct to Allison, and we can take it from there.
Awesome. Thank you so much, Lisa. So one of the first points that I'll make is a lot of the questions are very specific and detailed. So we can't answer all of them in detail because they would require each of us to apply our minds to the specific circumstances that a company finds itself in. But what I've done is I've reduced the questions to its essence and made it as generic as possible so that we could cover all the content that we can. But one of the first interesting questions, just to add some chaos to what's already chaotic, is recently the Department of Communications and Digital Technologies released their draft National Data and Cloud Policy. I can see your look already, Alison, but it's going to have a big impact. Well, it is drafted in a way that it would have a big impact on data and information within South Africa. And it's been heavily criticized for not having all stakeholders involved. But we just wanted to get your take on how you think it will influence information laws in South Africa, as we know that the information regulator has been engaged on this point?
So we have had a look at it. There are aspects of it that we disagree with. It is not a final document. So I think that's really is, I don't know that it's really useful to say much more right now. I think it's really important for people to engage with the process. As always, sufficient pressure from civil society does work, quite simply. And I think if people have concerns, I mean, what always worries me is where people have concerns, but they're worried about raising those concerns because, again, they feel like it's somehow aggressive or, it will result in them being, discriminated against or, and okay, if you feel that way, fair enough, but then put together a group of people or a group of organizations or a representative body and make concerns known that way. I mean, frankly, we stopped the secrecy bill, and that's how we did it. So I would say, that's a good lesson learned right there.
Perfect. Thanks, Alison. And I think it's vital to realize that we are living in a participatory democracy. So it means that we can get involved in those processes. John, I just want to check, did you want to add anything to that, or is it?
I'm fine, thanks.
Okay, perfect. The next question relates to the distinction between personal information and information under PIA. There seems to be a confusion, a general confusion about what types of information PIA deals with and what types of information PIA deals with, and accessing those different types of information.
I'm not sure that I can just sort of give you a sort of an off the cuff view on that. I think I've answered, I mean, to the extent that I've answered it already in looking at the distinction between records that are exactly that, records versus processing. I'm not sure that I can answer that question in any more detail than I already have.
Maybe if I can just give an example for me that shows the difference and what we're talking about here. If I cared about the environment, which I do, and I was worried that an organization was polluting the environment, I can ask for access to records of theirs that show how much they're polluting the environment. That's PIA. POPIA is a scenario where me, John, I'm a data subject, and I know that somebody's processing my personal data, be it a healthcare provider or a mobile network operator. And I want to know what personal data of mine they are processing and whether it's correct and what are they doing with it. That would then be a DSAR, or a data subject access request. And for me, that shows the difference. PIA is all information. POPIA is just personal information. And the two work together in that way.
Yeah, yep.
Just one thing on that is that the definition of personal information in PIA and POPIA is identical. It was changed. The previous definition of personal information was changed in POPIA when it was promulgated. So you still are entitled to look for your personal information, but as John says, there's additional information that you, if you can evidence a right to access to that information, you're entitled to request it.
Perfect. Thanks, Mark. John, I see your hand still raised. Is that?
Yes, there are just a lot of questions around the manual, and I thought maybe I'd just tackle that quickly. A lot of people are saying, well, there's a deadline for 1 July for a manual. And really, there isn't a deadline of 1 July. If you're exempt from having a manual, you probably will be exempt after 1 July to the end of the year, and probably after that. If you are not exempt and you need a manual, there isn't a deadline of 1 July. The deadline was in 2002. So there isn't really a deadline for a fire manual of 1 July.
And just to add to that, and I think it's something that I mentioned in the chat responding to Tanya, is that currently, since we're in that transition phase, the South African Human Rights Commission are still technically responsible for access to information. 1 July, that role fully goes over to the information regulator. From that perspective, you can still submit your manuals to the Human Rights Commission, but when POPI is in full effect, the law has changed. It says that you only need to submit a manual to the information regulator if requested. But not the one aspect that has changed, that hasn't changed, is that you still have to have it available at your place of business and at your website. So it is a weird thing to still have to submit it to a Human Rights Commission when really they're not going to deal with it. But that's what currently is in place practically.
Yeah. That was particularly, I mean, the Human Rights Commission was just deluged with PIA manuals. Their systems went down. It was a mess, and that's one of the reasons, Mark, as I recall it, as to why that was specifically taken out. You know, because it just wasn't. But yeah, you know, I think this is one of the things that is a bit baffling about PIA, is that it's almost though it sort of got trapped in amber in 2002, and it just sort of, people just forgot about it. It's been there all along. It's just now that there is a regulator that has power to, or will have shortly, the power to release records. That's the only change in substance, in my view, on PIA.
Fair point. Okay, Nathan, back to you with the questions.
Yes, so yeah, when it comes to the role of the information officer, there's been general hesitance from companies or people within companies to assume that role, and the concern relates to the obligations of that information officer, particularly now when it comes to both POPIA as well as PIA. And the idea is that the information officer is this sapiential authority that stands on its own, but I think some more of the concerns relate to the support structures for that information officer, and whether they'll actually be, well, using one of the wording in the questions, prosecuted for not doing a great job, where the reality is that no one knows what that great job currently looks like or should look like. We only have we have training, we have some training support, but if you could perhaps speak, one of the panelists could perhaps speak to that, and that it isn't the end of the world to be an information officer, but it is a crucial role for an organization.
See, can I just say at this point that the only reason, the key reason that the section was put into PIA that dealt with the criminal offence for failing to do a PIA manual was because business was so comprehensively ignoring the legislation. And this is always such a frustration for me, is it where you put something in place, it's as light touch as you can manage, and then people just decide it's a bad idea. And then what happens is that you ratchet it up and you ratchet it up, and the provisions come more and more punitive over time because of non-compliance. And I think this is one of those examples. So I would fairly squarely put the responsibility for that particular provision on the shoulders of people who just chose not to pay any attention to the legislation. it does, as a consequence, have a situation where people are very concerned about being information officers. There seems to be a feeling that you can decide who the information officer is, that you can delegate it, that you can find somebody else. Maybe you can get a company who tell you that they can help you with POPI compliance and they can be the information officer. And I've explained the genesis of the idea of the information officer, which is that they are the most important person in the organization, at the head of the organization, who leads the organization on information. It's you know, this pushback, this idea that now that we've, and I mean, this has been the case since PIA was enacted, which was in 2000. I mean, it was brought into operation February 2000, as I recall. You know, 20 years later, people are saying, I don't want to be the information officer. You've been the information officer for the last 20 years. What happened to you? Which jail cell were you locked up in precisely? If anybody can tell me that they have been criminally charged, found guilty, and sentenced in terms of those provisions, I would be very interested to discover that, because it's certainly not something that I know about. So I'm, you know, mystified by this sudden dawning of understanding that this is a role that exists in terms of the legislation. You know, I'm sorry if this is something that comes as news to people, because it really shouldn't. It's as I've said, the right to access to information is contained in the Constitution. It is a constitutional right. It is a right internationally recognized, and organizations, whether they are public or private, are governed by the Access to Information Act. And that's how that is. So like any other right, the right to equality, the right to administrative justice, the right to a fair trial, it is a constitutional right. And that's how the Constitution got written. So there's really no getting away from it, in my view.
Definitely. And I think maybe people are just conflating the role of a data protection officer from the GDPR with the role of an information officer, when they're actually quite distinct. And in some instances, you can have an external DPO, but you cannot have an external information officer. It has to be someone within the organization, as we said, senior management. Yes, John.
I think for me, the way I try and sell people on the role of the information officer is to say that if your organization depends on information, and it's a data-driven organization, and if information is the new oil, and that's the heart of what drives your organization, if you're the officer that's responsible for that, you're going to have your finger on the pulse. You're absolutely central and critical to your organization. And based on that, you're going to be a very important, well-remunerated person. I would jump at the opportunity of being an information officer. I am for about 2 or 3 organizations, but it's a fantastic role that has amazing career prospects, but also is just a fascinating role to be playing.
True. I'm looking at the time. I know we're over. I don't know if we have any more questions, or if we've really, if Nathan, you've distilled the generic questions, or we've answered them in the chat. Maybe we can take a few more. I don't know if everyone else is okay with just taking a few more questions.
I think from my perspective, I know that there were almost 100 questions, so there are lots, and we've been going for an hour and a half, which is a long time to go. I think what we need to try and do is to work through the questions that have been asked and possibly answer them through the Michalsons website, particularly if we see themes. We'll update the material and try and answer that so that as many of you can access that as possible. We'll also try, to the extent that we can, maybe respond to a few of you directly. But I think we're not going to get to all the questions now, and we need to really figure out a way of going into the future of resolving as many of them as we can.
That makes sense. Great. So from that perspective, I'd like to thank all of the panelists. I'd like to thank you, Alison, for joining us today. I think that this was a very informative session, and I myself personally have gotten a lot out of it and a better understanding of PIA from just a general perspective and why access to information is so important. So thank you. And as John mentioned, we'll try and answer questions either through our website or directly to you, but we appreciate that you've attended this session. I hope it was valuable to you, and I hope you all enjoy the rest of your day. Thank you.
Thank you so much. Thank you for inviting us.
You're welcome. Bye, everyone.
Thank you, everybody.
Thank you. Good to see you. Bye-bye.